So as we know, these are the two major regional trade agreements affecting intellectual property rights in the CARIFORUM region. The CARIFORUM EU Economic Partnership Agreement deals with many aspects of intellectual property rights. It also deals with ICT, telecommunications, but today we are going to focus on what it says on trademarks and geographical indications. Right? And we're going to mention the WTO trade-related aspects of intellectual property rights agreement. As you know, this was the first multilateral agreement at a global level to treat with intellectual property rights. Intellectual property rights, of course, don't exist for the sake of existing. They are very important economic assets of the private sector, or in some cases, the public sector. And therefore, it was felt that there needed to be global harmonization on the rights, on the legislation, and on the way in which intellectual property rights are protected. Trinidad and Tobago was the first country to pass fully TRIPS compliant intellectual property legislation. I was very fortunate to be one of the persons who worked on that with WIPO. And very soon other countries in the Caribbean followed. Today, every country except Guyana and Cuba has fully TRIPS compliant or largely TRIPS compliant legislation. So the trademark requirements are contained in Section 2, Articles 15 to 21, and GI Section 3, Articles 22 to 24. I need not repeat them here because I know all persons here are fully cognizant with these things. The basic rule established in Article 15 said that any sign or combination of signs capable of distinguishing the goods or services from one undertaking or the other can be a trademark. I remember when we worked on this in 1996 in Trinidad and Tobago, services actually were not, you could not have registered a service, and that was the same for most countries in the Caribbean and in fact in the developing world. You could not have registered a service mark. So all the banks, the Republic Bank or Microsoft, etc., could not have registered and protected their mark in Trinidad and Tobago and most of the Caribbean. So that was one of the groundbreaking and game-changing aspects of the TRIPS agreement for our region. Of course, the beauty of the TRIPS agreement was that we now have fairly harmonized legislation, procedures, examination requirements, and the way in which both trademarks and GIs are protected. And so back to the EPA, the CARIFORUM EPA has our obligations on trademarks in Article 144, registration procedure, which of course is very well implemented in the region, in most countries, the concept of well-known trademarks, which is also well established. And I can also tell you in 1996, that was also a fairly nascent concept of protecting well-known trademarks. There are obligations related to internet use and trademark licenses, and I will go into these two in a little more detail because those are two of our obligations which are not as well as implemented as the first two. Of course, there's the obligation to enter international agreements, and there's exceptions to the rights conferred by trademarks, which are also very well understood. On internet use, Article 144 speaks to the need for a clear legal framework for trademark owners desirous of protecting their trademarks on the internet, and it also obligates member states to participate in the development of electronic commerce. We also have Article 144D that speaks to the recommendations relating to trademark licenses. And these recommendations all deal with the simplification and harmonization of the registration of trademark licenses where they are required by a member state. Article 145F also has the same requirement as for trademarks and for all as per all the intellectual property rights for geographical indications. So where are we with these obligations? These two obligations that I noted are not completely yet implemented in the region. So the first obligation was for the protection for the use on the internet and for the encouraging and facilitating e-commerce law. So those two aspects have been in all countries except Guyana and Cuba, largely implemented through the UNCITRAL model law on e-commerce, which is contained in our Electronic Transactions Acts, which are omnibus laws. So starting around 1998 and going into early 2000s, WIPO was actually starting work on how to make sure intellectual property rights, including trademarks and geographical indications, are protected on the internet. And there was even talk about doing treaties. There was quite a lot of work done over a number of years. Then, because UNCITRAL was doing the work at a global level on e-commerce, there was an agreement that UNCITRAL basically will take over this work and prepare legislation that is then omnibus and will cover everything, including intellectual property rights. So this is something I have found from my 20 years work in the Caribbean, that many even senior civil servants, as well as persons in the private sector, CEOs, are not aware that the Electronic Transactions Acts are omnibus pieces of legislation and they cover everything. So they do cover your intellectual property laws. So therefore, where you have things like filing, signature, and payment in your intellectual property laws, even though they may not speak to be doing these things electronically, the ETA actually covers that. So that is something I need to clarify, because that is a question that often comes from registrars themselves, as well as persons in the private sector, because persons in the private sector are accustomed to also doing business. The lawyers and the proprietors are accustomed to doing business in Europe, are accustomed to doing business in the US or Australia, and they're accustomed to doing these things electronically. And then sometimes they are told we can't do it because the laws don't allow for it. So I'm just setting out that our law actually do allow for it in every country except Guyana and Cuba. And this is part of our obligations under the EPA. Right. So the ETAs allow for the WIPO system intellectual property to be used. Right. There is a bit of a problem now, and this especially relates to the obligations on licensing, trademark licensing, to make it fully harmonized and simplified. So we do have problems in terms of electronic signatures sometimes not being accepted. And to my knowledge, the apostilles are not in place in any English-speaking Caribbean country as yet. So in Europe, all of these things are a normal part of working life, a normal part of delivery of e-government services and intellectual property registry services. So, and these are requirements under the EPA. It's also, of course, just plain desirable if we want to move and take advantage of economic activities and trade. Right. With respect to e-apostilles, the Hague Conference on Private International Law has confirmed that there's no specific legislation required in member countries, and the majority of CARIFORUM countries are indeed member countries of the Hague Conference, to implement the e-apostille other than the functional equivalents already contained in the ETA. So there's actually no new legislation needed to implement a lot of these things, to implement e-certificates, to implement e-signatures, to implement e-apostilles. And if you want further information on e-apostilles, it's contained in here. And of course, I am also available through CarIPI to send any further information required. Right. And this is just a note that I was making about the differences in different countries. The smaller countries, such as Anguilla, Bermuda, BVI, and Cayman Islands, have successfully implemented these digital government initiatives, including e-registry services. And probably because the civil services are smaller and they depend more on international business and investment, so that they adapt more to the private sector. But in our current economic situation, whether you're a small country or not, it is advisable that you try to adapt to international business and investment. All right. Article 144 of the EPA also speaks to a session of the protocol on the Madrid Agreement. It speaks to exceptions to the rights conferred on trademarks. With respect to geographical indications, there are 6 items: protection in the country of origin, term of protection, generic terms, relationship between geographical indications and trademark, feature protection agreement, and of course, internet use. And I need not speak much on the first 5 because I know the speakers coming on will have a lot to say on that. I just wanted to point out the requirements of Article 145A, that CARIFORUM and EU states have no requirement to protect in their territories GIs that are not protected in the country of origin. And of course, there's the requirement to establish a system for protection of GIs before 1st of January 2014. And cooperation in respect of development through the CARIFORUM EC Trade and Development Committee. Right. Indefinite protection for GIs. Right. And these are the various issues that I know will be discussed by my colleagues later. Thank you very much.